All right, what was chapter 1 about?
Discussed our system, how it's set up, laws, and how our country works.
Okay. Courtney also said law. So chapter 1 is entitled Basic Law. The first part of the chapter talks about what?
Different types of law.
Different types of law, and what else? How does your book phrase it? Sources of law, good. So the first part of the chapter talks about the sources of law. We have 4 sources of law. What are they? What's the first one the book talks about?
Administrative.
Constitution.
Constitutional's first. And you said administrative. 2 more.
Legislative and judicial.
And judicial. Okay, the first one is constitutional law. And let's talk about the definitions. How does your book define constitutional law?
A law that is derived from the United States Constitution.
All right, good. So, your book defines constitutional law as that law as stated in or derived from the United States Constitution or one of the state constitutions. So, in the definition, it implies we have what? 2 what? Two types of what? Constitutions, good. So we have a state constitution versus the federal constitution. We say that the federal constitution is the supreme law of the land. Why is that? Why do you think we say it's the supreme law of the land?
They rule over all 50 states.
Yeah, so if a state constitution conflicts with what the federal constitution says, who wins? Federal, right? So the state constitutions cannot conflict with the federal constitutions. We also say that the federal constitution are the floor of your rights. What do you think we mean by that, the floor of your rights?
Like the bottom line,
Yeah, you can't go below the floor, right? So it's the bottom line. It's the bare minimum of your rights. So whatever you're given in the federal constitution as far as your rights go, the states cannot what? They can't
Superseded.
take them away.
Yep.
So states can't take away the rights that were given to you through your federal constitution. Can states give you more rights in the federal than the federal does? Sure, yeah. They can give you more rights. Anyone think of examples where the states are giving more rights?
Legalization of marijuana.
That's the popular one these days, right?
Different speed limit. Or those are.
Yeah, speed limits. That's another good one. Some states don't have the 75-mile-an-hour speed limit. I don't think Ohio does. Florida does, but not Ohio. And
Marriage,
yeah,
same-sex marriage.
same-sex marriage is another issue that's been popular. And OVI checkpoints. What are OVI checkpoints?
Where they can just stop you at random to check if you are intoxicated or above the legal limit.
Right. It's not really, the argument is it's not a random stop, it's a what? We're stopping what? Everybody's. So we're choosing everybody that comes past this point to be basically what? Stopped and what? What are they doing when they stop you at the checkpoint?
Sobriety test.
They're searching you,
Yeah.
right?
Yeah, right.
Yeah, stop and search. Are you allowed to stop and search? Is the government allowed to just stop and search for no reason, no probable cause?
No.
Apparently we are, right? That's why we have these checkpoints. Isn't that what it is?
Yeah.
You would consider that controversial then?
It certainly is, right? Is that constitutional?
Doesn't seem to be.
Doesn't seem to be, right? Because what are they doing? They're stopping you and searching you. Without what?
Which one?
Without a reason.
Just cause.
Just because you went past this point, you decided to drive past here, now you're going to get stopped and searched? What happened to our freedom?
But you can't fight it, right?
Well, you can fight it, but what did Ohio say?
Yeah.
Ohio said, or I guess not even just Ohio, but the federal constitution said these are what?
Well,
They're constitutional.
constitutional.
Now, Michigan said we're not going to allow these. So they're going to give their citizens more rights and not subject their citizens to this search and seizure. But the point is that states can and do give more rights than granted in the federal constitution, but they can't take away rights. So they can't take away your right to bear arms. They can't take away your freedom of speech, freedom of religion, freedom of press.
Bless
And the rights go on and on and on, right? The other thing our Constitution does is it sets up our rules for government. How does it do that? What does it say? We have to have a what?
Constitution.
Well, the Constitution, but the Constitution sets up our government. It says our government has to have a separation of what? Powers, good. What powers are we separating? Or how do we, let's even do, how do we do that? How do we separate our powers? How does the Constitution do that? We have what? Three?
The executive, legislative and judicial law.
Good, we have 3 branches of government. Executive, legislative, and the judicial. We have that separation of powers both on the state level and on the federal level. So what or who is the executive branch on the federal level?
Presidents.
President, right? What about our legislative?
Congress.
Congress? Good. And who does our judicial?
Supreme Court.
The Supreme Court. So those are our 3 branches of government at the federal level. What about at the state level?
Would be the governor.
Good, the governor. We have what, state legislatures and
And Ohio.
Ohio Supreme Court. Good. Oddly enough, in New York, their highest court is so-called Superior Court, and their lowest court is called the Supreme Court. So if you ever see cases out of New York and it says Supreme Court case, that's actually a common pleas equivalent to Ohio. And Superior Court is their state Supreme Court. And I believe that's the only state that's different. Everybody else has state Supreme Courts. So what power is separated into each branch? What power is the executive branch charged with as far as the law goes? Or any of the other ones that you can think of.
The executive administers and enforces the laws.
Good, enforcement. Yep. The executive branch is in charge with enforcing the law. What does the legislative branch do?
They create the laws.
They make the laws. Good. And last but not least, what's the judiciary charged with doing? Going all the way back to high school. Not so far for some of you.
Interpret the law.
Interpretation, good. So the executive branch enforces, the legislature makes, and the judicial interprets. And that's both for the state and the federal constitution. Any questions on constitutional law? You're gonna ace this on your quiz tomorrow, right?
Were those 3 set up to be essentially equal in terms of each other originally? In regards to their part, not being overseen by the others, or is that
Well, they were set up to have a check and balance on each other, so
okay?
in that sense, to the certain degree, they tried to make them balanced.
Okay.
And we'll talk about the checks and balances here as we go through, talking about the other sources of law. Let's do that. Let's talk about legislative law or legislative enactment. What did we say the legislature does?
Creates.
It makes the laws. So Congress, under the Constitution, is separated into what? to what?
House of Representatives and US Senate.
Good. So we have two houses. So we have what we call bicameral legislature. We have the House of Representatives and Senate. Who does our House of Representatives represent? The representatives, who are they representing?
State.
People in their district.
Us, right?
Right.
All right, yeah, their constituents. Same thing with the senators. Who do they represent? Us, right? How many senators do we have? That's the easy one, right?
Two for each.
Two per state, right? So how many senators?
100.
100, good. Now the hard one. How many representatives are there?
That's based on population.
Well, that's how many there are per district or per state, but overall, how many representatives do we have?
Was it 400 some?
Yeah, that's good. 435.
Yeah, probably.
It's always hard to remember that.
Yeah, right.
Does it always say that number, or is it the 435?
Mm-hmm. So, how do we make this? How do these laws get made at the legislative level? Let's say I have an idea for a law. I think that we should have traffic lights across the country at every intersection. No more stop signs, we need traffic lights. Regardless of the fact that I have a company that builds traffic lights, but I think it's a good idea. So, what do? How do I get that to be law?
You would talk to your representative. The House of Representatives have to essentially introduce the law.
Right, so since I want it to be across the country, I go on the federal level. So in our district, who would I talk to? I'm locally here. Not everybody might be living in the same district, but anybody have any ideas? Tim Ryan, anybody heard of him? So I propose the idea to Tim Ryan or his office, ideally in writing, and he presents it to the House of Representatives. What do we call it when he presents it to the House of Representatives?
Bill.
Good, bill. So we get a bill put together that gets presented to the House of Representatives. Anybody remember Schoolhouse Rock? I think I heard that guy passed away not too long ago. That created all that.
Yeah.
So what is a bill? It is a what? Back to our definitions. What's the definition of a bill? It's a what?
Describes the law that they want to create.
It's a proposal for a law, right?
Yes.
So a bill is a proposal for a law. So this bill gets introduced into the House of Representatives by Mr. Ryan. What does the House of Representatives do on it? What do they do with it?
Vote.
They may vote to see if they want to pass it into law, or maybe they vote it into what they call committee. What's a committee? Anybody know?
It's a select group of the House that will essentially formulate the law, maybe change it or improve it, or they may pass it as it is, or,
Great, yeah. So it's a group of congressmen that may even have a particular expertise in that area. So maybe we have a group of congressmen that have some experience with transportation or traffic safety or something like to that effect that will look at this law and maybe try to change it, make it better. Maybe they hire some experts to study it and do some research to try and help this become a better proposal. And the committee will work on that and they will vote whether they want to take it out of committee and present it to the floor of Congress with out of committee. So if it makes it out of committee, it goes to the floor of Congress again and they vote on it. What has to happen in order for it to become law? If it's reintroduced by the committee to the Congress, to the House of Representatives, they have to
pass it
by a what?
majority.
By a majority of the votes. So if it passes by a majority of the votes of the House of Representatives, where does it go? Good, the House of Senate. And what do they do with it?
They may vote on it as it is, or they may have.
They may do the same thing. They may have a
their
committee
own proposal, yeah.
and they may do some more research and more study. And then the committee has to vote on it and then present it to the floor of the Senate. And what does the Senate have to do with it to pass it? They have to vote what?
A majority.
By a majority. So after it passes the House of Representatives, the House of Senate, is it law? No, it has to go where? To
The executive.
the president.
Yes,
And he either what, signs it or doesn't sign it, right?
correct.
If he signs it, what happens to it?
It becomes law.
Good, it becomes law. If he doesn't sign it, what do we call that?
Vetoing?
A veto. Is that the end of it? Is that the end of our law?
No.
No? What can happen to it? It goes where?
It'll go back to Congress and they can override it.
Yeah, if it goes back to, if it's vetoed, it can go back to the House of Representatives, start over again, and what do they do with it? Same thing, right? They may go in a committee, they may change it to try and get it to pass, they may do some more research, they have to vote it out of committee, back to the House of Representatives. When it's on the floor there, it has to pass by what?
A little stricter guidelines.
Yeah, because if we're going to override a veto, we have not just a majority, but a what?
Like a supermajority. I'm not sure what the number is.
Nobody remembers the number. It's either 2/3 or 3/4, right? Which one is it? Nobody remembers? Ask Google, they always know.
I would imagine 3/4. I don't know. More stringent guideline. But
Well, let's look it up. Anybody have Google? It's not who knows the answer, it's who knows where to find the answer, right? Who's the fastest on Google?
I think I'd be the youngest.
it says 2/3.
2/3 majority,
And that's in both the House and the Senate.
right. Now, you tend to remember it better if you're looking it up. Yeah, 2/3 majority has to pass by a 2/3 of the majority of the House of Representatives. If it, at that point, it will override that veto. Where does it go then?
Back to the president?
Nope.
I think it becomes law.
Right now, we're at the House of Representatives. Where's it got to go?
It's got to go to the
It's
Senate.
got to go to the Senate. And the Senate has to override that veto. And what do they do to override a veto? Same thing.
Same thing.
Back in the committee maybe, rewrite it, research it some more possibly, present it to the floor of the Senate again, and it has to pass by a 2/3 of the Senate. So if the Senate overrides the veto with a 2/3 majority vote, where's it go?
It becomes law.
It's law at that point. The president does not have a chance to veto it. So that's the checks and balances that they have on each other. One can veto it, and one can override it. And that's some of the powers, to how they get balanced. So if the House of Representatives and Senate really want this law, even though the president's against it, we can still get it out there. So the majority of the people can override that president who has some of his power taken away. He can't just sit there as a dictator and say, no, we're going to do it this way. So no one person has superpower. So that is the whole process of legislative enactment. Any questions on that? Ace this on your quiz tomorrow, right? There's a lot in there. It's a wonder we ever get any laws passed. It took me 20 minutes to explain it to you. So far we've talked about constitutional law, our supreme law of the land, and we've talked about legislative enactment. Let's talk about judicial resolution. How does your book define judicial resolution?
Legislative enactment looks to the future and changes existing conditions by making new rules to be applied thereafter to all or some part of those subjects to its power. By contrast, the judiciary investigates, declares, enforces liabilities as it stands on present or past facts under existing law.
Okay, so the judiciary branch interprets the laws through what we call written opinions. So the judiciary interprets the laws through written opinions, and these written opinions are called cases. So the judiciary looks at a particular fact circumstance, applies the law, interprets the law to that circumstance, and issues a written opinion as to what they think is a proper interpretation of that. And that is called cases. Now, we have special kinds of cases, and decisions from those special kinds of cases have a particular name. So if we start with a case of what we call first impression, anybody want to hazard a guess what a case of first impression is? I don't remember if that was in your book or not. A case of first impression, what do you think that is?
How it's initially perceived.
Okay, that's a pretty good guess. It's a particular fact situation in which the court has never heard those circumstances before. Whether it be interpreting a new law or a new type of situation for the law to be interpreted.
So there's no precedent.
Exactly. So what is a precedent? Well, a precedent is a decision from a case of first impression. So that is a precedent.
A decision what?
A decision from a case of first impression is a precedent. So basically, a written opinion from a case of first impression is the precedent. And again, a case of first impression is a situation in which the court has never interpreted before. back in 2005, they changed the bankruptcy code. And so we had some new law that had to be applied. And I was lucky enough to be one of the first ones to argue a case of first impression and establish a precedent. Not too many attorneys get to do that in their career. But because of the change in the law and the circumstances, our office came upon a case of first impression.
May I ask, was that done before a Supreme Court or?
Well, it started at it had to start at the trial court, so it started
Okay.
at the federal
Okay.
bankruptcy court,
Okay,
and no one appealed it,
okay.
so we didn't have to go to the Supreme Court.
Good, okay.
But it did set the precedent for all the cases thereafter.
Okay, so you'll be referring to that case for future decisions?
That
down the
decision,
road?
yeah. In fact, the day I argued it, pretty much all the local attorneys were there listening to see what the decision was going to be. Then it came favorable to our client. So a case of first impression sets the precedent. Why is precedent important? Well, we have this process or this doctrine called stare decisis. What does stare decisis say? This I know is in your book.
I think that's kind of a term that they don't want to be re-arguing the same cases again and again and again. That'd be
Well, that's the reason kind of for
very
stare decisis.
Time consuming.
What does stare decisis actually say? What's the doctrine? How does it work?
Below are two actual cases showing this doctrine work. The U.S. Supreme Court struck down Sign's ban back in 1970. However, real estate companies were under siege by fair housing activists were reluctant to go into court as plaintiffs with cases involving race. Thus, cities got away with outlawing signs in their communities for decades. Finally, communities had outlawed signs that those in real estate industry were forced to become active on pursuing the rights in this issue.
Okay, so that's kind of an example, a particular example of how it would work. But let's talk about it in general. What's a stare decisis? How would we define that? If you had to explain this to a layperson or someone that had never experienced this before, how would you say or how would you express stare decisis?
Does it look at past similar cases to help make their decision?
Okay. Let me boil it down for you. Lower courts, under the doctrine of stare decisis, lower courts must follow higher courts' precedents. What do we mean must follow? In other words, if a precedent is set at a higher court, that lower court must what? They must make the same decision in that same situation. So what do we mean by lower and higher courts? Well, turn to page 14 in your book, and you'll see on figure 1-1 there, our court structure. They have a diagram there for our court structure. Notice we have two columns. What do those two columns represent? One represents what?
The state level?
Good, the state courts, and what's the other column represent?
Federal.
Federal courts. Good. So on the state system, what's our lowest court?
Municipal or county courts.
Yeah, the municipal county courts, common pleas courts. On the federal system, what's our highest court?
Supreme Court?
Supreme Court, federal Supreme Court. What about on the state system? What's our highest court?
Iowa Supreme Court.
Still the federal, yeah. Yeah, you can still appeal state decision to the federal Supreme Court if you need to. So, hence, the Supreme Court oversees everything. So there's two ways to get to the federal Supreme Court, either through the state system or through the federal system. What's our lowest court on the federal system?
U.S. District.
Good, U.S. District Court.
Does Ohio have one of those courts here?
We have two. We have a northern district and we have a southern district. Pretty much, they cut the state in half through Columbus. Anything north of Columbus is the northern district. Anything south of Columbus is the southern district. So, if a precedent is set at the United States Supreme Court, so the United States Supreme Court, they hear a case of first impression, they interpret it, make a decision that sets the precedent. Who has to follow that precedent? Everybody. Same question on the state level. If the Ohio Supreme Court has a precedent and they make a decision, who has to follow that?
Everybody in Ohio only.
Right, good. Only in Ohio. Do Ohio state courts have to follow federal court decisions?
Yes.
No, they do not.
Okay.
Only the Supreme Court decision. So if there's a federal district court decision or a federal appeals court, Ohio does not have to follow that. And then chances of a federal case affecting a state case is not likely because federal law and state law are two different laws. So only if it's applicable, you might be able to argue that the decision should be followed in the state case, but it does not have to be. So only if it's possibly related. But once it goes to the Supreme Court, then it has to be followed. Well, some people tend to think that federal overrides state on every level, but it does not.
It sometimes gets a little confusing because you've got all these U.S. district courts.
Exactly.
For example, with the immigration issue here, the one in California ruling against the president at that time. But I think that's been overturned since.
Right.
Then. But it does get.
It does get cloudy. Yep.
It does.
So, stare decisis is the doctrine of precedent set in higher courts must be followed by lower courts. Why do we have that? Why do we have stare decisis? What's our reasoning? What's our policy?
I think it's natural for a person to re-argue cases. I think our courts would be so overpopulated with a lot of cases if we were re-arguing the same cases again and again and again. Does this kind of maybe keep a lot of that at bay where people aren't wasting time on cases that have already.
Well, it definitely helps streamline the process.
Okay.
What else does it do? Why else would we have this?
To kind of give them some guidelines to follow. You don't have to make every decision. I mean, some decisions already.
But why do we want that? Why do we want guidelines?
So the state doesn't get too much power.
Well, not just that, but if you are in the same position as John Doe, and John Doe got this decision, what would you want?
Equal playing field.
You'd want the same decision that John Doe got, right? So what does that do then? What does stare decisis do? It makes it what? It makes it equal and makes it fair. All right, so the process of stare decisis is the attempt to make this a fair system, an equitable system. It also streamlines the process. So that is judicial resolution. Any questions on that? This is how our courts interpret cases. Now, let's take a little break here and talk about definition review. If I talk about common law, whenever I say at common law or common law, I'm talking about judicial resolution. Okay, so common law is another term for judicial resolution. I may also say case law. If I say case law, I'm talking about judicial resolution. I'm also talking about common law. So common law and case law are pretty much the same thing. It also is sometimes referred to as judge-made law. Why do we refer to it as judge-made law? Any reasoning behind why we call it judge-made law?
Judge made it.
Exactly, because the judge is making the decision, right? The judge is making the decision, he's interpreting the case. He's interpreting the facts for the case. Oftentimes, they're the ones writing the opinions. So judge-made law, common law, case law, all means judicial resolution. Let's talk about legislative enactment definitions. Anybody know what we normally call a legislative enactment? When we're in court or we're talking in general, we don't say, hey, did you see that new legislative enactment?
Trial law?
Statute.
Statute. Good. Yeah, most of the time we're talking about statute. So if I say statute, I'm talking about judicial or legislative enactment. Another term for that is code law. C-O-D-E, code law. Why do we call it code law? Well, does anybody know what we call our collection of statutes in Ohio?
Revised code.
Good, Ohio Revised Code. Hence the term we shorten it up to code law. State code is Ohio Revised Code. If you look behind us, all the red books on the back there and the glass shelves and behind the monitors, that is our Ohio Revised Code collection. Just a few books, right? So if I talk about OREC, or the ORC, the ORC stands short for Ohio Revised Code. That means code law. That means statute, which all boils down to what? Legislative enactment. Law that comes from the legislature. And we also have it on the federal level, right? What do we call it on the federal level? Federal code, or what else? What do you think we call it? Kind of common sense. What do we call our federal code?
The Constitution.
What's that?
The Constitution.
No.
No.
Statutes created by Congress. What do we call it? Well, if Ohio Revised Code is state statutes, what would the
Federal statute.
almost United States Code? All right, USC, United States Code. So again, if I talk about USC, I'm talking about United States Code, code law, statutes on the federal level, which means federal what? Legislative enactment. And these are terms that'll come up throughout the class, so you need to know these terms so you know what we're talking about. If I'm saying common law, you know I'm talking about law that came from judiciary. If I'm talking about statutes or code law, it's law that was made at the legislature. And that applies to real estate quite a bit. There's a lot of common law that affects real estate, and there's a lot of statutes. All right, any questions so far? We've talked about constitutional law, legislative enactment, and judicial. All right. Gonna be on your quiz tomorrow. Well, everybody should get an A. There's no questions, right? All right, the last one we need to talk about is what? Administrative law. This is the one we haven't spoken about yet. And save the best for last. Let's define it. Let's define administrative law. That's pretty simple. If you had to summarize it up in your own words, what would you say administrative law is? Law that what? Comes from administrative agencies. It's that simple. All right. Administrative law is law that comes from administrative agencies. Anyone think of some administrative agencies? What are administrative agencies? Some
In
examples.
Ohio, would Department of Commerce be an administrative agency?
Yes. How many administrative agencies are there? Are there state ones and federal ones?
President and governors.
Yeah, the president and the governments, they're the executive branch. They're the ones in charge of these administrative agencies. They're the ones that set these up.
I'm not sure how many in the federal government, but would like, is
I wouldn't say a
agency-
number. In general, how many do you think there are? We don't have to have a specific number. Are we talking 10?
10 or 12, I would think.
Oh, there's hundreds.
Hundreds, okay.
Hundreds. What's the big one that everybody always dislikes on the federal level? 3 letters.
IRS.
There you go. You didn't have to describe that too much.
No.
Yeah, the IRS, that's an administrative agency. What else?
You got this Census Bureau, is that one, or,
I think they fall under a different
okay.
administrative agency. I don't.
I mean, there's one for housing,
Yeah, which one? There's one fixed real estate. What do we call that one? HUD,
but
Department of Housing and Urban Development. What else? What other housing ones?
Like, is Fannie Mae, are they the same thing as HUD? Fannie Mae, is that similar? No?
No, Fannie Mae is not an administrative agency. What about FHA? What's that stand for?
Federal Housing Authority?
Fair housing.
Fair.
Fair housing. What is the fair housing? What are they in charge of?
Like public housing?
Yeah, they're to make sure that housing is administered fairly and equally, equitably. What about on the state level? What are some state administrative agencies? What about the EPA? Right? You have federal EPA, state EPA. That affects real estate. Can't build on wetlands, can you? EPA says no, unless you do what? Get a permit. What about the FAA? What's that stand for?
Is that the Federal Air?
Aviation, yeah.
Yeah,
Mm-hmm. FCC,
That's the
Federal
TV
Communications.
stations,
Communications, yeah. That's why and it goes on and on and on. We have the FDA. What's that stand for?
Yeah, drugs.
Food and Drug Administration. Yeah. You think about it, you can go on and on and on. You know, on state, we have OSHA, the Bureau of Workers' Comp, we have the CSEA, CSB. Let's talk about how we get the law from these administrative agencies. So, I mean, those are some examples of them. How does law come from administrative agencies? Well, they have a process. They have a process called rulemaking. What do you think that stands for? It's pretty simple, right? What is it?
Guidelines.
They make the rules, right? They set up the guidelines, they make the rules. They have a process where they do that. Then they have an adjudication process. There's some of those big words I was talking about. Anybody know what adjudication is? Anybody want to guess? What's it sound like?
It be enforcing or?
Kind of interpretation. It's like a judicial process, a quasi-judiciary. So they make the rules, and then they have kind of like a court proceeding to see if the rules are violated or to apply and interpret those rules. And then the third, they have some kind of enforcement from those rules. Whether it be suspension, fines, or maybe even an injunction. What's an injunction? There's another rule, another big word. Anybody know what an injunction is?
Where they may request you to stop.
It's a stop, yeah, it's an order to stop. An injunction is basically a stop order. Whatever you're doing that the injunction applies to, you have to stop. So what does this process remind you of? Does it look familiar? It does? What's familiar about it? We've talked about it through the whole class. It's kind of like what? It's even on the board.
Constitutional.
It's kind of like what? Right?
3 branches.
The 3 branches of government, right? What does the 3 branches of government do? Let's start with the legislator. What do?
Create the laws.
They make laws. Sound like rulemaking? What's the judiciary do?
They enforce it.
Judiciary.
Interpret.
They interpret the laws. Kind of like adjudication, right? And then the executive branch,
Administer.
they're enforcing or administrating the laws. Enforcement. So, We're supposed to have 3 branches of government for what? Why do we have the branches of government to what? Separate the powers, right?
Right.
Separate the powers into different branches. These are what? All 3 powers where?
Within the administrative.
Within the administration. Let's talk about on the state level the administrative agency that puts you in this class. Does anybody know? Does anybody know the administrative agency that made the rule that you have to take this class?
Is that the Commission of Real Estate?
Good.
Under the
It's
comments?
OREC, the Ohio Real Estate Commission. And this is on your state test, so they love to test you about them.
You say it again.
Now we want to pay attention. The Ohio Real Estate Commission. They are the people, the administrative agency that puts you in this class. The state administrative agency that puts you in this class. They are the ones that came up with a rule that said you have to have courses before you can sit and take your test to get licensed to be a real estate agent. Years ago, you never had to take a course. You just had to pass the test. And before that, there wasn't even a test. So over the years, they have changed it. Before the test, you just applied and became a sales agent under a broker. So as the years gone on, they've refined it. They got to a test, then they got to, well, not a lot of people are passing this test. Maybe we should make them take courses. Then they came up with 4 courses. And it used to be equal time in each course. It used to be 3 weeks for each course. And then probably about 12 years ago, they changed it to be 4 weeks for law, 4 weeks for principles, and then 2 weeks for the other 2. And there's been talk about maybe requiring a degree now before you can get, maybe a 2-year degree before you get a license. That's been bounced around a little bit. I know you have to have a 2-year degree to become a broker. And they were talking about maybe a 4-year degree to be a broker. So the OREC is the one that puts you in this class. Who makes up the OREC? This is on your state test. Who is the OREC?
Is it a group of 5 people?
Good, it's a group of 5 people. It's in chapter 11. Even though we're not going to lecture in chapter 11, look it up, chapter 11. Look up the OREC.
And I think a lot of the commissions are where they have one person is like a lay person to the field who represents kind of the public.
Mm-hmm.
And then the others usually they choose are people within the field that may have some background in it.
Yep. So let's look it up and read it. Let's read that statute. Chapter 11. Look up the OREC. Because they love to test you on this at your state level.
I've got it here. It says.
What page is it on for
It's
everybody?
on 317, on top of 317.
So everybody go to 317. What code section of the revised code is it?
It's 4735.03 and 4735.04.
Okay, good. You don't need to know those statute numbers. All right. But they do put it there for reference. What's it say?
It has 5 members appointed by the governor with the advice and consent of the Ohio Senate. 4 of these members are licensed real estate brokers for at least 10 years immediately preceding the appointment. The 5th member is not a member of the real estate industry, but from the public at large.
Okay. So you have to be, 4 of them have to be brokers that have practiced at least 10 years. And then the last one is just representing the public. And who appoints them?
The governor.
The governor. So when the governor appoints these folks, do you think he knows them?
Yes,
How well?
actually very well.
Probably helped them what?
Buy his home. or
Helped them
sell
buy
a
his home?
Or sell a home.
Probably helped them do what else?
Get elected.
Get elected, right?
Yes, right,
Now return that favor, right?
right. We see it in dental too. I mean, set up the same way.
So, the ORC is appointed by the governor with the advice and consent of who? The Senate. I don't think they have too much input. They're like, okay, whatever you want, governor, right? And then that fourth or fifth person is from the general public. You think they know the governor?
Probably.
Probably really good, right? Probably over for Sunday dinner. All right, on a local level, what is an administrative agency that affects you as licensed real estate agent? If you have a dispute with another agent about maybe a commission, who would you go to? Would you complain to OREC?
Would you go to the broker first?
Yeah, I mean, the broker's the one that has is the only one that's allowed to receive and pay commissions. So I mean, you're always going to your broker, but your broker, when they're arguing with another company or brokerage, how does it get resolved? Do they go to court?
Are there systems set up for like arbitration and stuff like that?
Yeah, we have a local administrative agency,
Okay,
which is what? They're called the local what? Anybody know? Local Board of Realtors. You all have to become members of that when you get licensed and work under a brokerage. The brokerage is going to require you to become that. Anybody know the name of the local one in Trumbull or Youngstown? Y'all take either one. All right, Trumbull County is called WABOR. Stands for the Warren Area Board of Realtors. Youngstown, Columbiana is YCAR,
You said Warren Area Board of Realtors.
Warren Area Board of Realtors.
What's the other one?
Youngstown and Columbiana have they merged it, and it's called YCAR. Stands for Youngstown Columbiana Area or Association of Realtors. And you as agents can be a member of either one or both. So who makes up these boards? You guys, your members, right? And anybody know how a board works? Like a board of directors? Anybody know how that works?
I think there's an election process.
Yeah, you elect
You elect
Who?
people who are members.
president,
Residents.
vice president, treasurer, secretary, just like any other board. So you elect them, and where do these people come from that get elected?
Within that
From the membership.
membership
So you guys become members, you can what? Run for
board.
board president. Get elected. So as WABOR or YCAR, these are administrative agencies. These administrative agencies administer real estate law. They hear commission disputes, they hear ethical complaints from the public, or any other complaints, whether it be from an agent or public. So sometimes you can resolve this, any kind of dispute you have at what we call the local level. If you can't get it resolved at the local level, sometimes then it's referred to the state level, which is who? Who resolves the disputes at the state level? Complaints.
Ohio Real Estate.
Good, the Ohio Real Estate Commission. We talked about that. So these are all administrative agencies that affect you as real estate agents. And notice what we said administrative agencies do. They make rules, they interpret those rules, and they enforce these rules. So Waybor and Wycar, they're making rules. And who are these people that are making the rules? They're the president, vice president, which were elected from where? From you guys, right? From the membership. So when you elect the president, vice president, and treasurer and all that for the Waybor, that's going to make these rules, interpret the rules, and enforce the rules against you, who are you electing?
Your peers.
Your peers, but more importantly, your what?
Competitors.
Your competitors. So you guys are putting your competitors in a position to what? Make your rules, judge your rules, and enforce those rules. So the person that makes the rule is also the same person that is interpreting that rule. You think they're going to think it's a good rule?
Of course.
Yeah. And then they get to enforce that good rule that they made. Because there's no what?
Check and balance.
Yeah, no check and balance, no separation of power. Are you going to get a fair shake?
Maybe.
You like to think so, right? Do you think they're biased in any way?
Definitely.
Definitely.
But do they have to go by precedence after they rule on something?
They're making the rule. They can say, this precedent's over with. We're going to make a new precedent. Is that a good idea? Well, when I interpret it, I think that's a good idea, right? Because I made the rule. So if you don't get a fair shake here, what can you do?
That's where you go to your court system.
No, where do you go on a state, local level? You go to the Ohio Real Estate Commission. So who makes up the Ohio Real Estate Commission?
Us.
Which is essentially what?
Peers.
Your competitors. Now it's less intimate because it's on a state level versus the county level, but they're still your competitors. So your competitors, again, at the state level, making rules and judging you, interpreting these rules. Going to get a fair shake? Every time I've gone down to Columbus with agents on license issues, we have not gotten a good shake. I always tell my class and I tell my clients, don't go to Columbus. Whatever you got to do to stop the complaint, to not get a complaint, whether you're right or whether you're wrong, resolve it. It's not good. Going to Columbus is not good for any reason.
Has anybody tried to change that system to make it more fair?
Hmm?
No, maybe.
Of course. I had a client who followed the law. By all rights, we did not violate any law. We litigated it. He was in the right. He had every right to what he was saying. We went to Columbus. They didn't like the way he handled things, and they have this catch-all unprofessionalism. They decided at Columbus that he was unprofessional, suspended his license for a month, and fined him $1,000, even though he didn't break any laws. That's the short. It's a long story, but that's the short end of it. So They love that catch-all unprofessionalism.
So that's where the brokers, they can either carry that insurance and take care of the legal fees and all of that, or?
Well, generally that insurance doesn't cover license issues. It only covers legal issues. So legally, we could have went to court and won our case, but the person that was complaining didn't go to court. They went to the state, complained to the state, got his license suspended and fined, but he didn't get any money out of it because the state doesn't pay them.
Right.
And if we'd went to court, we would have got our money because it was over a commission amount. And time again, when I've gone to the state with real estate agents, we have not gotten a fair shake, again and again. So now at the local level, sometimes we've gotten a fair shake. We've gotten out okay, but if you get to the state level, forget it. So I always say, don't go to Columbus. You know, try and resolve it here, or try and resolve it, period, before you even get to here. And don't stand on principle. Just make that complaint go away as best you can. And it's on a case-by-case basis is what we do. You feel free to call me with any kind of advice you need. But it doesn't come up that often though either. So you guys don't have a lot of, it's not like you have a high malpractice or a high, your E&O is not very expensive because you tend not to have these issues.
So can they appeal that? Can you then appeal that to OREC? Or no?
Appeal what to
Any
it?
kind of,
Well, I mean, the local level, we appeal to OREC. But we don't get a fair shake at the OREC. I mean, that brings me to my next question. Is this stuff constitutional? Are administrative agencies constitutional? The Constitution of the United States says you have to have a what? Separation of powers. Are these powers separated? They're not, are they?
No.
So are they constitutional? The Constitution says we need to have a separation of powers. We don't have it. You could argue that administrative agencies are not constitutional. Are they constitutional? Are they?
Don't seem to be.
They don't seem to be, but what? How many do we have? How many did we say we have? Hundreds, right? So they must be what?
Constitution.
They must be constitutional because they exist in hundreds of them. So how do we argue that these are constitutional? How do we make them constitutional? Because on their face, they're not, are they?
No. Are some of these agencies making up their own rules?
That's the whole point. They are making up their own rules. Rule making, that's what they do. They are not only making their own rules, they are judging those, interpreting those, and enforcing those. That is not constitutional.
So really the only recourse you have is going to court, which is,
There's how we make it constitutional.
Right.
At the OREC level, at the state level with the OREC, if you don't like their decision, where do you go? You appeal their decision to the courts. So then the argument is, well, once you get into courts, where are you? You are now where? Here. So now you're aware in a separation of powers situation. So therefore, these are constitutional because now you're going to get your fair shake.
at a cost.
Right. And I don't think you're going to get a fair shake.
Right.
Back to my story. What do you think we did when we had a case where we followed the law and we didn't get a good decision? What did we do? We appealed. Where do you appeal the OREC decisions? Anybody know? Anybody want to guess? Do you go to Supreme Court? No. Where would you go?
Would you start in the court system?
You start in the trial courts.
Lower levels?
Yeah, you start at the lower level of trial courts. So in Ohio, you can either go to the county court in Columbus, which is Franklin, or the county court locally, where you're practicing. So where do we go? Where do you think we went?
locally?
Locally, right? Save our 3 hours to trip down the whole 9 yards. So we appealed it to the Trumbull County Common Pleas Court. Now, what kind of cases do Common Pleas Courts hear? You see it on the news, right? What kind of cases?
criminal, civil,
Yeah, when you hear these criminal civil cases, what are they? Like, what kind of cases? Some examples. Murders, robbery, right? You have personal injuries, medical malpractice cases, people getting killed and injured. Where on the list of cases does your appeal of your real estate license go?
way low.
Way at the bottom, right? That's not going to be a priority for this court to hear your case, are they?
No.
So when we appealed it to Trumbull County, how long did you think it took before we got in front of the judge?
A couple of years maybe, or
6 months, more than 2 years.
is it 5 maybe, or 6?
Still
10
waiting?
years?
7 years.
7 years,
Oh.
wow.
7 years before we got our appeal. 7 years.
So what happened with his license?
Well, the suspension was stayed during the appeal process
Oh,
and the fine. So, but we had 7 years of waiting to get in front of the judge. 7 years later, after all the evidence had been already heard at the state level. Now, think about this. We have the judge at the common pleas level. What do you think he knows about real estate license law?
Nothing.
Yeah.
What's told.
Unless he happened to be practicing somehow before he became a judge in that area, he probably knows zero. So he has to then become educated, right? Who has to educate him?
The attorney.
The attorneys. So even if we educate the judge very well, who knows the most about real estate license law in this situation?
The real estate agent.
The Ohio Real Estate Commission, who did what?
fine. you.
Already made a ruling, right? So where's the judge already slanted to?
That's
Towards
good.
them.
Towards that these guys knew what they were doing and already made a ruling. So it's practically a what? Rubber stamp that he's going to agree with whatever they came up with, especially 7 years ago. And how much does all this cost?
Quite a bit.
Quite a bit. This particular situation, it was a dispute over a commission of $2,000 difference. It was 8,000 versus a 10,000.
Just eat it and move on.
That's why the broker wanted to stand on principle.
Yeah.
He was right. He could win it. Wouldn't give it up. Spent way more than $2,000 dealing with this. And ultimately got his license what? Suspended and fined $1,000.
So if the broker gets his license suspended for a month, does that suspend the agents too?
Mhm.
or- So it costs them a lot of money.
Usually what they'll do, this particular broker didn't have any agents, but usually what they'll do is they'll have a broker come in and serve in the meantime so the agents don't get hurt. So the lesson is what? Don't what? Don't go to Columbus. Even if you're right, don't go to Columbus. Don't stand on principle. I hear that all the time from my clients in my practice. But it's the principle of the thing. It's like, well, get ready to write a big check when you want to stand on principle. We'll see how much principle you want in like 6 months from now after writing checks. I hear that. It's the principle of the thing, and then 3 months later, like, let's get out of this. Okay. So that's how they become constitutional. They get put into the 3 branches of government. So notice that all of this, legislative, administrative, judicial, all comes from the Constitution setting up the rules of government. Hence, constitutional law, supreme law of the land. It is the source of everything in the United States. It's the primary source of all law and government. Because everything The other three sources all flow from the start of the Constitution. So our four sources of law are Constitution, administrative, legislative, and judicial. What's the next area that the book talks about? Page 11.
Civil law versus criminal law.
Yeah, let's talk about that. What's the difference between civil law and criminal law?
The criminal is the court justice of one party against another for enforcement or protection against a private or wrong, for redress or prevention of private wrong. And then the civil suits include actions against both and laws and equality, equity.
Okay, you just described all civil law. Yeah. You're saying criminal law, but it's civil law. Civil law has to do with what? What did you say?
One party against another for enforcement or
Of what?
protection against a private wrong.
Private wrongs, good. So civil law has to do with correcting of private wrongs. Anyone think of some examples of private wrongs? What are some civil cases we have? What's going to be the big civil case as real estate agents you guys always get involved in? If there's going to be litigation, it's going to be a what? Most likely.
That's a commission.
Which is what? What kind of case? What do we call that? Anybody think? Has to do with what? The type of case, though. What was the wrong? Anybody hear that? Breach of contract, right? So, a big part of real estate is all about what? Contracts. Right? We have real estate purchase contracts, we have listing contracts, option contracts, leases. These are all contracts. And what is a breach of contract? What does that mean?
Not paying the
Not paying, but not what? Not performing. Whatever the agreement is, whether it's paying or performing or doing something. So that is what, not performing on a contract we consider a private wrong. Anyone think of some other examples of private wrongs? Not necessarily related to real estate.
Would divorces be in that?
That's a kind of a breach of contract kind of thing.
Yeah.
Yeah, but the divorce, what else? What's personal injury? Anybody know? When we say personal injury, what are we talking about?
Auto accidents.
Yeah, somebody was injured somehow and they need compensation, whether it be from a malpractice or an auto accident, falls, slip and falls, etc. So personal injuries are private wrongs. Wrongful death, what's that? That's a type of personal injury. What's a wrongful death?
Surgeon.
Or somebody got not just injured but killed, right? So you can recover civilly for that. Let's contrast that to criminal. What does criminal law have to do with?
Murder?
Well, that's a type of criminal case, but the civil law is private wrongs. Criminal is what? Punishment of evil acts. Okay. It's an offense against the public. So as a society, we don't tolerate this. So can you have a wrongful death and also a murder from the same circumstance, the same act?
Yes.
You bet, right? So murder would be an example of a criminal case that could also result in a wrongful death lawsuit.
Like a DUI or, I mean,
The best example was the O.J. Simpson case, if you guys can remember, if you're old enough to remember that. No, they didn't find him what? Criminally, that he was
guilty. but-
guilty criminally of murder, but they did find that he may have caused their death. Which brings me to the next difference between civil and criminal law is our standard of proof. Standard of proof is different between each one of them. What's the standard of proof in a criminal case? Everybody usually knows that.
Pretty high.
What do we call it? Anybody know?
Guilty.
Guilty
Reasonable doubt.
beyond a reasonable doubt. Okay? Standard of proof in a criminal case is beyond a reasonable doubt. Does that mean beyond any doubt? No, because unless you as the jury or judge actually saw the act, there still will be some kind of doubt, but the question is it reasonable? Has the prosecution proved beyond any reasonable doubt that this person committed that act? In the O.J. Simpson case, they were not able to prove beyond a reasonable doubt. There was some doubt there as far as the jury was concerned. What's the standard of proof then in the civil case? One of those fancy law terms, begins with a P. It's in your book.
Preponderance?
Good. Preponderance of the evidence. What does that mean, preponderance of the evidence?
It's a little bit more than not.
Good. The greater weight. Whoever has the greater weight of the evidence, whoever has more evidence than the other party will win a civil case. Now, notice, and I advise my clients of this all the time, preponderance of the evidence does not say how much evidence you have to have. It could be very little evidence, just as long as you have what?
Something.
More than the other side. As long as you have more evidence on your side than the other side, you win. As opposed to what? The criminal standard, which is you better have quite a bit of evidence. You know, this goes to the amount of evidence that you have to have. This just says whoever has more wins. So you could have zero, one side could have zero and the other side could have a feather. You win. And it's hard oftentimes to get lay people to understand that. Because everybody wants to always apply this standard, even in a civil case. So when we're making our litigation choices and our decisions as to what we're doing, we have to take into account the preponderance of the evidence versus the standard that you get in a criminal case. So what happened in the O.J. Simpson case? Was it more likely than not that he was the one that caused the death of those people? That the jury found that. They found that it was more likely that he was the cause of their death than not. But could they prove beyond a reasonable doubt? No. What are some other differences between civil and criminal?
There's potential jail time for criminal cases versus civil cases?
Yeah, the punishment is different, right? What do you have at risk in a criminal case?
Jail time.
And
fine.
the loss of freedom, what else? Loss of money through fines, what else?
Loss of life.
Loss of life. Depending on the case, you could wind up losing your life. What's at risk in a civil case?
Just money, right?
Yeah, mostly money. Or there might be an injunction where you might have to stop doing something.
So in a civil case, they can suspend your license also.
License suspension would come from an administrative agency. Unless it's, a traffic thing.
Right.
But a professional licenses would be an administrative agency. What are some other differences between civil and criminal?
In criminal, you have the right to an attorney, and if you can't afford one will be appointed to you.
Good.
And in civil, you only get one if you can afford it.
Exactly. Yeah, you get more rights as a criminal than you do as a civil case. So as a civil defendant, you do not have a right to an attorney. Unless you can afford one, you don't get an attorney. What do?
Represent yourself.
You got to represent yourself. You know what they say about an attorney that represents himself? Anybody ever heard that? The attorney that represents himself has a fool for a client. Yeah, and when I have legal issues, I don't represent myself. I hire attorneys for myself. Because you can't advocate for yourself. It's very difficult. It's much better, much more believable if somebody else is pleading your story than if you're pleading your story. So just in the fact alone that you have an advocate is worth the money for the attorney. Not to mention all the other advantages. I always say, don't leave home without your lawyer. So, in a criminal case, if you can't afford a lawyer, they will what? They will give you one. The court will give you one. What are some other rights that you get as a criminal that you don't get in a civil case?
You don't have to testify.
Good. You have the right to plead the Fifth Amendment in a criminal case. What do we mean by Fifth Amendment? What's the Fifth Amendment say?
Can't incriminate yourself.
Yeah, they can't force you to testify against yourself. But in a civil case, what can they do? They can call you as a witness against yourself. All right? And they did in OJ. OJ did not take the stand in a criminal case, but he did in a civil case.
At that point, they can't force you to say anything. He could say, he's invoking his Fifth Amendment right?
In a civil case?
You
No,
have to testify?
you have to answer the questions.
Oh,
Now, if he hadn't had his criminal case yet, he could plead the fifth until the criminal case was over, and then they could continue the civil case.
Ultimately, he could plead the fifth, but lose his case, right? You automatically lose his case.
No, you don't automatically lose the case if you plead the fifth.
I mean, in a civil case, I mean, he won't plead the fifth, but he just doesn't answer the question.
Well, and if you don't answer the question in a civil case, the judge will find that you are in contempt of court, and the judge will then put you most likely in jail until you do answer the question.
So there is a chance to go to jail in civil, possibly.
Well, you're not going to jail for the civil case. You're going to jail for violating a court order. There's a difference.
Or, oh, I didn't, watching the trial, but were they able to ask him questions about?
In the civil case, they asked him all
same
kind of
that
questions.
he asked-
Yeah.
was asked in the criminal?
They point blank asked him in the civil case, did you kill these people?
But at that point, even if he said yes, he was already found not guilty, if he would have said yes, so there's no.
I would imagine if he said yes, they might have found a way to try him on something else. So you have a right to an attorney, you have a right to plead the fifth. What other rights do you get as a criminal that you don't get in a civil case?
Is there like a speedy trial thing that does, that
Yes.
case went for years, they can't do that?
Yeah, under a criminal case, you have to have a speedy trial. So your trial has to be brought within what? 30 days. Now, oftentimes they're not, because the criminal defendant with their attorney will waive the right to a speedy trial to give everybody time to prepare for the case. But you don't have to waive your right, and they have to bring the case within 30 days. So they can't just file charges against you, lock you up, and forget about you. That happens in other countries. Other countries don't have speedy trial statutes or constitution. They'll charge you with a crime, and you'll have your trial 2-3 years from now while you sit there waiting to be tried. What else? Speedy trial, plead the fifth, attorney. You have a right to a what?
A jury?
A jury, good. In a civil case, you do not have a right to a jury.
You do have the right or you don't?
You do not in a civil case. You can ask for a jury in a civil case, but they do not have to give it to you. And if you do ask for a jury in a civil case, you have to pay the jury out of your pocket. In a criminal case, you have a right to trial by jury of your peers. What if you don't want a trial by a jury of your peers? Can you not take a jury trial as a criminal? Can you ask just to have your case heard by the judge? Hmm?
No.
No? No, they will give you the option. You can have the option if you want to have a jury or not have a jury in a criminal case. Sometimes in complicated situations, you don't want to try and educate the jury. You want somebody like a judge who's familiar with the law, familiar with procedures to make a decision versus having to educate a jury and hope that you get through to them as to what you want. So it's a strategic decision that we make as attorneys, whether we want a jury or not in a criminal case. Especially if it's a financial crimes, when there's tons and tons of paperwork to go through. And then you look at the judge you get, look at the jury jury area that you're in. Lots of decisions to be made. So you have a right to a speedy trial. You have a right to trial by jury. You have a right to plead the Fifth Amendment. Any more rights? And that pretty much covers it. So those are the rights that you get in a criminal that you don't get in a civil. The standard of proof is tougher in a criminal case versus a civil case. Why? Why do we give criminals more rights than we do civil?
Punishment is harsher.
Yeah, the result, right? The consequences are much more severe. So we want to protect our criminal defendants as much as possible because we don't want to what?
Make their own.
Have an innocent person get punished for something they didn't do. Does that happen? All the time, right? All the time, more often than you think. Even loss of life. All right, so those are the differences between civil and criminal law. Any questions on that? All right, moving on. Page 14, court structure. We talked about that earlier in class when we were talking about judicial resolution. But we need to talk about the different types of courts we have on that court structure. The first one is what we call trial courts. What are our trial courts in our court structure there?
Common pleas, municipal, and county courts.
Good. So on the state level, common pleas, municipal, and county court are our trial courts. What about on the federal level? On the federal level? It's on your diagram there.
U.S. District?
Good. Yep, our federal trial court is district court. Now, the trial court has two questions that they have to resolve. They have two main things that they have to get done. What are they? The first thing your trial court has to do is decide what?
There's actual charge to.
What law applies, right? So they have to resolve what is the question here of law. And there's two types of law that the trial court looks at. They look at procedural law and substantive law. Anybody want to hazard a guess what procedural law is? What do you think procedural law has to do with? What's it sound like?
Procedures.
Procedures, good. So the procedure law deals with how the court proceeds or the rules of court. So we have laws that say what the court has to proceed, how the court has to proceed. On TV, when you hear the attorneys objecting, that's what they're objecting to. They're saying they're objecting to procedure laws. They're saying some type of procedure is not being followed when they object. So they're saying that the other side is not following the rules of the court. One of the big ones or often ones is hearsay. It's objection, Your Honor, that's hearsay. Anybody know what hearsay is?
Something you get through somebody else if you weren't directly there at the.
Okay, good. It's a statement or something that happened outside of court that's being offered in court as to try and prove the truth of the matter. It has to, whatever you bring to court has to be present in the court. So if you said John Doe said so-and-so, well, John Doe needs to be in court to be able to say, yeah, I did say that. Otherwise, whatever John Doe said outside of court is not admissible in court. All right, so that's procedural law. The courts have to make sure the procedures are followed, the trial courts do. And what's the substantive law then? It's going to be the law that what? It's the law that's the subject matter of the case. You know, did in fact they breach the contract? Did in fact they, committed the personal injury? So substantive law has to do with subject matter, procedural laws, the rules of the court. And that's one of the first thing that the courts have to determine, the trial courts. The other question is what? If we determine what the law is, we have to determine then what?
Guilt.
Not guilt, but what? How do you get to guilt? You have to look at what?
Evidence.
What is it?
Evidence.
Evidence or what? Facts. Right? We look at the facts. Which is evidence, etc. So we have to determine the law, and we have to determine what the facts are. That's the trial court's main duties. What's the other type of court we have? We have trial courts and we have what? Begins with an A.
Appeals.
Good, appeals court. The appeals court, they only have to determine one question, one issue. What's the question that they have to determine?
Somebody made an error, the previous court made an error,
Error in what, though?
their judgment, or
Which is, what are they judging?
error of law or abuse of discretion.
Law, right? So they have to resolve question of law. Whether it be procedural or substantive. The appeals courts only look at, was the law followed correctly and applied correctly? They do not look at the facts. Contrary to what people think, appeals courts do not determine the facts. You only get one shot at that at trial court.
So if there's found to be an error, do you then go back to trial court?
The appeals court gets to decide what they want to do
Okay.
with the error. So they can send it back to court. They can say we need a whole new trial, or they can send it back to court and saying that it was ruled wrong, ruled this way, and then continue with the court, because you can actually stop a trial court in the middle and file an appeal in the middle of the actual case, depending on the situation. Or you could say, we don't need a new trial. We don't need to go back to court. We're going to rule this way, and that's it. What are our appeals court on the state level?
Court of Appeal.
Ohio Court of Appeals, what else?
Common Pleas?
No, that's the trial court.
Six.
Ohio Supreme Court.
The Ohio Supreme Court, good, that's an appeals court on the state level. Right? So the Supreme Court does not determine facts. The Ohio Court of Appeals does not determine facts. What about on the federal level? What are our appeals court?
Sixth Circuit.
Sixth Circuit Court of Appeals, right? There's different circuits, and we're in the Sixth Circuit here.
Can you say that again? You said the state level appeal was which one?
The state level appeals courts are the Ohio Court of Appeals, and then we have the Supreme Court. And technically, you can even go to the federal Supreme Court as an appeals court for the state. So you have 3 levels of appeals court when you're on the state system. On the federal system, you have what? The Sixth Circuit Court of Appeals, and then the United States Supreme Court as a Court of Appeals. Did the appeals courts have to take your case?
No.
No, they don't?
You do once, right?
Good. Yes, you are entitled to at least one appeal. Everybody gets one appeal. So if you want to appeal it in the state level, you get to go where? For sure, you get to go where?
The Ohio.
The Ohio Court of Appeals, and on the federal level, it's the Sixth Circuit Court of Appeals, if you're in the federal. Now, after that, where are you going in Ohio? Ohio Supreme Court, and on the federal level, United States Supreme Court. Do those courts have to hear your appeal?
No.
No. They can decide whether or not they want to hear your appeal or not. Now, just because they don't hear your case, your appeal case, does not mean they don't make a decision. They do have to review every appeal request. But when they say they don't want to hear your case, they're what? They're making a decision of what?
That you don't have a case, or?
That the lower court was what?
Right.
Correct. All right, so they will review your case. If they don't hear your case, they're saying we agree with the appeals court. If they do agree to hear your case, that is called grant of cert. It's a short for a Latin word called certiorari. Everybody just calls it cert. If you get cert from the Supreme Court, it means the court's willing to hear your case. Any questions on this? Trial courts versus appeal courts. Procedural versus substantive law. Questions of fact versus questions of law. We're going to ace it all of them are, right? No questions because we got it down, right? Okay. Moving on in the chapter. We have some alternate means of resolving disputes, which is called arbitration and mediation. What is arbitration?
Contractual way of settling disputes.
Right. Through arbitration, it's a contractual way of settling disputes. How does arbitration work?
You present your case in front of somebody who has been given the authority to make a decision.
Right. So we call that person an arbitrator. So you agree with the other party to have your case resolved through arbitration, which an arbitrator is appointed that sits there as like a judge, and they hear the evidence presented by both sides. And it could be one arbitrator, or across will be a panel of 3 arbitrators. Sometimes arbitration agreements agree to have one person pick an arbitrator, the other side to pick an arbitrator, and then those 2 arbitrators pick the 3rd arbitrator. Or some is just one arbitrator. It's less costly with just one. The rules of evidence are usually relaxed in arbitration. So the procedure for arbitration proceeding is not as stringent as in a court situation. But an arbitration proceeding proceeds as like it is in a court. Evidence is presented, and arbitration, a decision is made. Now we have 2 types of arbitration. We have binding and non-binding arbitration. Binding arbitration is just what it means, is whatever decision the arbitrators make, the parties agree to be bound by it. As opposed to what? Non-binding arbitration, which means what the decisions binding the arbitrator come up with, the other party does not have to be bound by.
So they could still take the case to court?
They could still go to court
With that
and
one?
continue with that one.
Okay.
I don't know how effective non-binding arbitration is, because there's always somebody who's usually not happy. Sometimes it resolves issues.
But same thing if there's the sitting judge that is off for a personal reason or something, to get an arbitrator, is that binding or non-binding? Does he still have to present everything to the judge, or?
Well, you're confusing things there.
Okay. Never mind.
A judge who is on vacation or whatever will have somebody as a sitting judge, but they're still in trial. They're not in arbitration. In arbitration, you're agreeing to have your case heard in that arbitrating setting.
I notice a lot of the contracts for like car, or if you buy something, there'll be a clause in there, if there's any disputes, it must go through arbitration or something.
Exactly. Credit card companies, they love to put that in there. Anything that has to do with consumer finance, these finance companies love to arbitrate versus going to court.
And that's just to help reduce costs and things like that, or?
Help reduce costs, and they usually get favorable decisions from these arbitrators. What it is, especially with the consumer thing, is the legislature has enacted statutes to protect consumers, especially Ohio. We have some of the better consumer protection statutes. If you agree not to go to court and go to arbitration, what happens to those statutes? They're not going to be applied. So that's how they get around some of these statutes. I mean, my brother litigates those all the time, the consumer protection statutes. Well, under those statutes, you're entitled to your attorney's fees. You're entitled to sometimes 3 to 5 times what you're damaged, plus punitives. So they're some of them are very strict and very harsh penalties on these companies that violate these. But if you've signed up for an arbitration, that takes all that off the table. Guess who's paying for an attorney now? And lots of times they say, well, in arbitration, you don't have to have an attorney because it's not court. Well, I'd want an attorney, even if it's just arbitration. Let's compare that to mediation. Mediation is another way to resolve your disputes. How does mediation work?
Is it where they bring the two parties together, and you've got a person there that tries to work out an agreement between the two, maybe each
You
party?
don't bring the parties together necessarily, not physically.
Okay.
You come between, as a mediator,
Okay.
come between the parties,
Okay,
and you'll become basically a communication conduit,
Okay.
right? And you try and get the parties to come to an agreement. You folks as real estate agents oftentimes are going to be what? Mediators between who?
the seller and the buyer.
The seller and buyer, right? It's kind of like that old saying, don't ever let your what? Buyers and sellers meet.
Yeah.
Oftentimes you get your buyers and sellers together, what's going to happen to your deal?
Out the window.
It could very well go out the window.
Yeah.
Yeah. And I've seen that time and time again. Do not let those buyers and sellers meet. Keep them separate, be the communication conduit between them. Whether you're an agent that is representing both buyer and seller, or you're an agent with another agent representing you guys as agents, keep those buyers and sellers separate.
Yeah.
I know my mother-in-law just recently sold her house, and just by circumstance, she ran into the buyer on a home inspection. They came to the house to home inspect. My mother-in-law was there, started talking to the buyer. The next day, the buyer called and went out of the deal. And I'm like, why do you want out of the deal? What's going on? And here, my mother-in-law had just lost 2 pets. And she said she was talking to the new owner saying, yeah, I just lost my dog and my cat just died. And the new owner was a pet person kind of thing. And they were like, well, I'm afraid to move in here because I don't want my pets dying.
No
And
doubt that's their
we had to explain that, the dog died. It was a pug. It was a 10-year-old pug, and that's about all the pugs live to, is about 10 years. Because just out of nowhere, this pug just dropped over, so it died. And then the cat had gotten into a cat fight and had an abscess on it, and that got infected and caused its death. Had nothing to do with the house. But that deal fell apart. I had to put it back together. Threatening lawsuits and everything else. You can't just breach a contract because you don't want, you think your pets are going to die. But had they never met, would we be dealing with that? And over the years, I've been practicing in this for over 25 years, I've seen it time and time again. When your buyers come together and sellers, it's very likely that something could happen. Because buying and selling a house is very emotionally charged for both parties. So emotions run high, tensions run high. You don't need them getting into it with each other. I mean, just the very fact alone is, a seller has a house, the buyer's immediately going to want to do what to that house when they move in?
Make changes.
Make changes. And the seller has the house a certain way because they what? They like it that way, right? Usually they like it that way. So when you have the buyer start telling the seller what they're going to do to that house, that could go haywire. So as mediators, keep your buyers and sellers separate. And that's how you're effective. That's how mediation is effective. You're a communication conduit. So when you have two parties disputing as that communication conduit, what are you going to filter out between the parties?
The emotions.
All the emotions and the unnecessary communication, the name calling and all the other good stuff, and just get to the facts, right? And that's how you can bring these parties together and become an effective mediator. And that's how it becomes effective as an alternate means of dispute versus going to court. So we can, short of going to court, we can do a mediation, or sometimes we go to court and the judge may say, why don't you guys try mediation before we go to trial? So we do that a lot in court, is we have a mediator come in between our parties and try and get the resolution that way. Or sometimes we do arbitration even after we file court. The judge says, why don't you try arbitration before we go to trial? All right, any questions on arbitration mediation? All right, let's talk about civil procedure. Under civil procedure, yes.
Does anybody in here have a cell phone I could call and use? I just got done state testing and there ain't no cell phones anywhere to call.
What number do you need to call?
Thank you.
Oh, you can, okay.
Sorry to interrupt, it's vacant here.
Okay, so under civil procedure, another way of resolving our dispute is settlement. What is a settlement?
Both parties are happy.
Both parties come to some kind of an agreement to resolve their dispute, all right? And I often tell my clients, it's called a settlement, not a win, for a reason. Because both parties give up something in order to get the settlement. Because oftentimes, my clients would come to the view, well, we're going to settle this, I'm going to get what I want. Well, no. That's why it's a settlement. You give up a little something, they give up a little something, and we try and resolve our dispute that way. Now, the question, if we are attempting a settlement, are those negotiations admissible in court? The fact that you're trying to settle your case, can I bring that up in court? Can I say, look, Your Honor, they must be liable because they are trying to settle with us?
I don't think you can can, because that would influence the,
You're exactly right. You can't, because that would say no one would ever try to settle if we're allowed to do that. And just because you're trying to settle doesn't mean you're liable. I often advise my clients, don't stand on principle. Even if you're right, you may want to just settle. Don't go to Columbus, right? Okay, under civil procedure, we have these things called pleadings. What are pleadings? How does your book define pleadings?
Parties to a lawsuit transmit to each other in the court, to the court, the legal wrong complaint of and defenses to those asserted wrong.
Okay, yeah, so our pleadings are ways we communicate with each other in a lawsuit. We have primary pleadings, and our two primary pleadings are our complaint and our answer. This is on page 20. The complaint is the document that starts the case. So the plaintiff drafts a complaint and files it with the court. And basically, it's just what it means. It's what the plaintiff is complaining about that the defendant did wrong. So the complaint names the plaintiff, and then it names the defendant, and that pleading is served upon the defendant. That's what we mean by service and summons. Part of that service of that complaint includes a summons for the defendant to come to court and answer that complaint. So under civil law, when you get served a civil complaint, civil procedure requires the defendant to answer that complaint within 28 days of being served. Not within 28 days of being filed, within 20 days of receiving it by service. If you do not answer a civil complaint within 28 days, then you could possibly be found in what we call default, and you could automatically have a judgment against you. So you need to answer or appear in court to answer the complaint within 28 days in a civil case. And the answer is just what it is. You either admit or deny whether those allegations are true or not in the complaint. Sometimes in an answer, we may have what we call a counterclaim, which says, plaintiff, not only am I not did what you said, I'm suing you back. You're the one that did me wrong, and you owe me money. At which point, the plaintiff has 28 days to what?
to answer.
To reply to the counterclaim. We call it a reply, not an answer, but it's the same idea. So if we're filing a reply, it's an answer to a counterclaim. Again, definitions, definitions, definitions. We need to talk about third-party practice. Under third-party practice, we have cross claims, which is a lawsuit between two parties on the same side. So let's say a plaintiff files a suit against the defendant. Well, maybe there's multiple defendants. Maybe the defendant says, well, the only reason I'm in this is because you did me wrong, Mr. Defendant, and I'm going to sue this other defendant on the same side of the case. That often happens on medical malpractice, where the doctor, hospital, nurses all get sued. And the nurse says, well, I'm in that position because I followed the doctor's orders, so I'm going to sue the doctor back. Doctor sues the hospital, goes on and on and on. Once we have our complaints and answered filed, the case goes into what we call discovery phase. And you'll often hear this with attorneys, that we have a phase of the trial where we can try and discover all the evidence that's going to be brought up at trial. And there's different tools that we use to get this evidence in ahead of time. In general, we try and get all the case information as much as possible to try and resolve the case short of going to trial. So unlike what you see on TV with Perry Mason, they come in at the last minute and say, I got the smoking gun. You know, if you had the smoking gun at the beginning of the case, you need to present that to everybody so that we can just resolve this without having to go through the trial. And some of the ways we do that is what we call depositions. Anybody know what a deposition is?
Is it where the opposing party can ask questions of a particular person that might be relevant to the case?
Right, and it doesn't have to be an opposing party. We can depose anybody. Most likely we're going to depose the other side because we know what our clients are going to say. We talk to our clients and we know what their testimony is going to be, but we want to know what the other side's testimony is going to be. So that's what a deposition is. We call the other party and have them testify as to what questions we're going to ask them at trial, and they have to answer. They also have a court reporter there to write those down. Why would we have a court reporter there to write down the answers?
Make sure they don't change their.
In case they change from what they say today on the stand, they may have a different answer. We can say, well, what's the deal? Depositions are not cheap. They cost a lot in attorney's time. You have to pay a court reporter. The other side has to pay their attorney, and they're not quick, and you have to prepare for depositions. You can't just set them up and start asking questions. So there's quite a bit involved in the deposition. So if we could try and resolve or find out some answers without having to do depositions, we have what we call interrogatories. And this is where we can serve written questions on the other side that they have to answer in writing back to us. But they're usually only limited to like 40 questions. You can't ask as many questions as you want in like you do in a deposition. On interrogatories, you're limited to 40. But you should see how I can write a question. So it's not really just going to be necessarily a 40 question answer. We can also look at books, subpoena books and records. We can ask to go on the land to review that. We can get court order to go on the land. On page 24, we have what we call requests for admissions. These are written requests where we ask the other side to admit certain things to save us some work on having to prove it. The most popular one is just, please admit that your company is an Ohio LLC or whatever, so we don't have to go to the state of Ohio and get all the records to prove that you're an Ohio LLC. And there's other things like that where we request and save court time and money and aggravation. Once we get all our discovery, we look at the summary of it, and at that point we start our motions based on the evidence that we've collected in depositions and discovery. So sometimes we can look at the case and say, here's the evidence, there's nothing you're complaining about. Nothing under the law provides for a relief for you. So then we ask the court to dismiss it because there's nothing there based on what we looked at. That's very rare because most of the time, if you have something to complain about, there's usually some kind of issue that has to be resolved that you're complaining about. So then we may look at what we call a motion for summary judgment. What the motion for summary judgment says is, hey, Your Honor, or court, based on the evidence that we found, that evidence is in our favor and you must rule for us. That's what a motion for summary judgment is. These happen quite a bit, and we argue back and forth whether the summary judgment applies or doesn't apply. And a lot of that is done at what we call pre-trial. And pre-trial is where we sit and we talk with the other side and the judge and try and resolve the issue based on our discovery, based on what we found out. If we can't get anything resolved through motions or pre-trials, then we start our trial. And we're all familiar with trials and how those work, I hope. Once we get to our trial, they will get a judgment from the trial court, and we can start our appeal process. That pretty much wraps up chapter 1.